Yes, Mr. Cobble.
Good morning, my lady. One or two points outstanding on grounds 2 to 4. Firstly, the question of hardship payments. It turned out that I was right, but for the wrong reasons. The numbers are very small, a few hundred during the period affected by COVID. In a normal year, the 9,000 figure which Mr. Delamere gave to you is there or thereabouts. We don't have exact figures, but that's 9,000 hardship decisions each month, and these are decisions which are taken each month for each person. So if there are 9,000 decisions in January, 9,000 in February, that doesn't mean there are 8,000.
Probably 9,000 a year, or there or thereabouts. It's not 100,000 or so. Right. It's of that order. Okay, it's a monthly, repeated monthly figure. Yeah. I mean, we're just trying to get a feel. We don't need accurate.
Yes, no. So as a feel.
Broadly, yes.
I don't dispute the figures. My lady asked whether the DWP take into account local authority and safety net support, and the answer is a little complicated. The context, of course, is that these are individuals who have an entitlement to universal credit, which is then removed as a result of their conduct, and the Secretary of State needs to satisfy himself that his withdrawal of his reduction of their entitlement does not breach his convention rights obligations. And so the focus is very much on what money should the Secretary of State restore to the individual rather than anybody else give to the individual in cases of hardship. The position is complicated by the provision in the regulation that you were shown, Regulation 116. I don't need to ask you to turn it up, but it's 116 2b, whereby one of the matters taken into account in deciding whether somebody is in hardship is whether they've made every effort to access alternative sources of support to meet or partially meet their needs.
That's what I had in mind when I asked the question.
And the guidance to decision makers invites them to consider whether reasonable efforts have been made to secure alternative sources of support. It doesn't mention in terms local authority support. It does mention friends and family. So I can't say absolutely we don't take this into we do or don't take this into account, but it's certainly not at the forefront.
Thank you. Well, I'm sorry a lot of time was spent on that slight red herring.
I understand the point. And a similar point was made by my learned friend with reference to the W case, which was about the policy for waiving the NRPF conditions on right of residence in hardship cases. The suggestion, I think, also which comes from the Upper Tribunal's decision, the suggestion was that the Home Office somehow conceded in that case. This is paragraph 138 of the Upper Tribunal's decision, that the Home Office somehow conceded in that case that Section 17 support was not adequate to satisfy any hardship issued in the NRPF context. And we checked with the Home Office, and it is true that they didn't argue that that Section 17 was the answer in cases of people with children, simply because they took a view as a matter of policy that it was preferable in hardship cases to restore benefit entitlement rather than to hold up the local authority system in that context. But there wasn't a concession at all that Section 17 doesn't work or isn't adequate in any particular case.
Is it your case that Section 17 is a complete answer, or does it require supplementation?
Well, Section 17 is an answer, we say, and I say an answer, in some cases, i.e. cases where the claimant has a child or children, and Section 17 may only be one of the potential sources of safety net support. It's perhaps the first port of call where children are concerned, but there are a lot of other potential local authority and other safety net sources of support that we enumerated to the Upper Tribunal. But it certainly is the answer, we say, to the question: how does the United Kingdom as a whole, the government of the United Kingdom, ensure that there are no breaches of Article 3 of the Convention, Article 4 of the Charter, if it applies. It is the Children Act and other local authority safety net is ultimately what we say stops situations of that severity arising.
And you're clear that it's local authority safety nets. That's in accordance with your understanding of your obligations, that it's for you to decide how you allocate the duty to secure protection. I'm really asking this question.
Yes.
Are you accepting it's a mixture of central government and local and decentralised, or only local authority?
No, it's a mixture. So for example, one of the basic needs which we would accept that needs to be met on the threshold test is the need for healthcare, and that's provided primarily, of course, by the NHS. Centrally provided for by NHS England, locally by NHS Trust. That's just one part of it. We're talking about other basic needs that may be satisfied pursuant to the Children Act or other local authority mechanisms. But looking at the system as a whole.
Sorry to interrupt, but I'm having some difficulty with this part of your argument. You are, of course, entitled to make it, and certainly my impression over the last couple of days is that Section 17 has become far more centre stage of your argument than I perceived it to be when I read the papers. That's probably my fault. But there's an awful lot of authority about Section 17 and about potential effectiveness, including some authorities about what happens if it potentially infringes Article 3 and limitations in Schedule 2 of provision of accommodation. I mean, there's just loads and a huge amount of complicated authority in both the administrative courts and the families court about assessment of need and what that means and when it turns into a breach of duty. Now, if you are, as I think you are, in answer to my Lord Justice Green's questions, putting Section 17 at the absolute heart of your argument, I find it difficult that we haven't had any of this put before us in order to support your argument that Section 17 provides, effectively, where there are children, a complete answer.
So, Milady, I don't accept that it's not at the, hasn't been at the forefront of our case. it was argued both in the First-tier Tribunal and in the Upper Tribunal. I'm not saying, and I hope I'm make it clear to my Lord Justice Green, that Section 17 is the whole answer, even in cases where children are concerned. It is part of a network, an overall structure, which comprises a number of different possible local authority, in particular, safety net support mechanisms, including matters like homelessness, duty, Localism Act powers.
Well, I understand
Care
that, but
Act.
you just said to Lord Justice Grimm a few moments ago, it's the first port of call where there are children, and you said, and I've written it down, it is the answer as to how does the government of the UK ensure there's no breach of Article 3 and 4. That's what your submission was a few moments ago.
Excuse me. So, Melody, what we say is the...
Just 1 second. I wonder if, Mr. Delamere, do you want to just, Chinese whispers, I sort of half heard what you were whispering in confidence.
Well,
do you want to just express it so that Mr. Koppel can then respond to it properly?
As I understand from Mr. Royston, who is something of an expert in these matters, we are in a position where those with pre-settled status are actually excluded from the homelessness power.
Just to fit assist, the case of A and Barnet, which was going to be heard immediately before this one, and was settled as between the appellant and the local authority, was a homelessness case.
Exactly.
Yes.
And the appellant now was excluded, the local authority said, in precisely these circumstances.
So that's been, well, is that compromised on the basis that the tribunal judgment is correct?
It was accepted that she had to share her rights and therefore wasn't excluded.
Right.
Her children had entered full-time education.
Yes.
I
see.
see. So as we found the ultimate outcome in this case, in fact.
Absolutely.
But
if you go
to that,
before that, it was a homelessness case.
Right.
If you go to the updating regulations, what you'll actually see in the updating regulations is a list of all the benefits and all the forms of social assistance from which you are excluded on the basis that your right to reside under PSS is insufficient to qualify you for the rights.
No, I'm sorry,
Do you need a moment, Mr. Koppel? Are you content you've been able to take instructions?
Well, can I accept what Mr. Delamere says for now, and I'll withdraw my reference to homelessness powers? There is a little complication, but I just don't.
Inevitably.
I just don't have the.
You have my sympathy.
so can I? Sorry. So we get it down. What precisely do you accept? So we're talking about limitations on the applicability of Section 17 to certain categories of person.
No, it was homelessness. I think it was, sorry to cut across you, it was that we were being told by Mr. Delamere via Roy that the PSS, there's a list available of all the different benefits that people with the same status as AT are not entitled to as a consequence of their limited residence. Have I summed that up correctly? Is that what I was told? Yes.
So, can I?
If I can assist on that, if you go to tab 10 of the authority, you'll find the social security income related benefits.
And so tab 10, bundle 1.
Yes.
Yes, thank you.
We've got here the relevant regulation that excludes eligibility for universal credit. But what we can do is obtain the full regulation. And you'll see Regulation 2 excludes you from this benefit, Regulation 3 excludes you from it. My Lord Justice Dingemans may recall from the Fratilla litigation that there were a couple of benefits. I think housing benefit was originally left off, and council tax benefit was originally left off, and then there was a further amendment to remove eligibility for that. So there's a rolling list of benefits and forms of social assistance.
Yes, yes, and it may be, Mr. Coppell, I don't want you to have to dance on your feet to try and deal with this. I mean, would a sort of one-page note agreed between all of you,
I'm sure we can
sent
agree.
up afterwards, then we're not going to waste time going through this, and it's very difficult for your instructing solicitor to give you proper instructions and for you to take them on the hoof like this.
Thank you. So let me proceed without reference to homelessness, and let me take you back to paragraph 68 of our skeleton argument. And I didn't mean to say that the Children Act was the answer. Paragraph 68, which I took you to in opening, which contains a reference to a list of other types of safety net support, which we had put before the Upper Tribunal. And then there are some others mentioned also in paragraph 68. I don't think we have the Care Act on that.
I don't think we need it. I think we're in danger of going down a rabbit hole here.
Well, Melanie, the point in substance is that there are safety net mechanisms which we say are sufficient to prevent breach of Article 3 CHR, Article 4 of the Charter, if it applies. The Children Act has been at the forefront in this case, and it will be important in all cases where children are involved. But there are other mechanisms as well, and the fundamental point then is that on the distribution of responsibility which Parliament has provided for, there is a mechanism, there is a system which prevents breach of Article 3, and that is why one simply does not have cases. I mean, in some exceptional situations, there are some authorities, a handful of cases where Article 3 has been seriously an issue, but one simply doesn't have that on a routine basis because the system is there.
And would it follow from that on your analysis there's no need for a new, dignity scheme, because the existing safety nets cumulatively from whatever source are adequate?
Yes, absolutely. There is no need for a new system, for example, of individualised assessment of children's needs set up by DWP, which was the implication of some of what my friend was saying. We have a system in the Children Act. We have social workers, we have social services departments. I accept it may not always work as effectively as it might, but that's the system that Parliament has provided for. We don't need to reinvent it. And the point about legal priority that I made in opening still applies, that as a matter of legal priority, local authorities have a duty in a Children Act case where there's an imminent breach of Article 3, they have a duty to act. Secretary of State not only doesn't have a duty, he doesn't have a power to grant universal credit under the scheme provided for by Parliament.
Subject to the effect of Section 7 disapplying.
Subject to
etc., etc., etc.
To the argument in this
Yes, quite.
case.
Yeah.
Now, was that your top up on 2 to 4?
That's my first point.
Are we moving on to ground one now?
Not quite, my lady. I just want to say something about the section 17 in AT's case. There is an assumption running through the submissions of my learned friend that there was a failure on the part of the local authority in AT's case, which is indicative, symptomatic of wider failings in the system. But we say there's simply no warrant for that on the evidence and on the findings of the First-tier Tribunal in this case. There is no record of local authority decision making. There's an account of what the local authority did, but we don't know why they decided to give the limited support that they did. And they may have done so. They may have done so because they considered that what they were doing was sufficient to meet AT's basic needs, and therefore no real safety net issue arose. And on our submission, they would have been right to consider that this wasn't an imminent breach of Article 3 case. On individualised assessment, which is ground 2, we've been dealing with the system point and our primary submission that one simply has to ascertain what is available potentially in a case of imminent compromise of human dignity. Subject to that, then, there seems to be a measure of common ground. I think the Air Centre no longer says that there must be an individualised assessment of all the circumstances in every case, and is more aligned with my learned friend Mr. Delamere. And then one is into the semantic argument, possibly about when you are working out who is vulnerable, whether that involves an assessment or what kind of assessment it involves. So
I think you accepted in principle yesterday that one way or another, the system has to identify those who are individually in the vulnerable situation, and it might be said that provided you get to the end result, the structure by which you do so, subject to it being timious and so on and so forth, is neither here nor there. That's what's meant by individualised. You must get to a correct individual result. I mean, there may be a difference between result and the structure of the way in which you get there. Individual interviews for X tens of thousands of people, or slightly forms which categorise people into blocks and so on and so forth.
Yeah. So if I'm wrong about you simply have to ascertain what the system provides for. If I'm wrong about that, then yes, I accept what my Lord says. We have to identify who is in the vulnerable category in some way. Turning then to ground 1. My learned friend submitted that the withdrawal agreement couldn't have provided for what we said contend for, which he described as a human rights free-for-all. But of course, that's really not what this case is about. The UK applies convention rights and has its Human Rights Act, and the expectation was that it will continue to do so. My Lord Justice Dingemans questioned on more than one occasion whether this case was really something of an arid debate, in the sense that everyone accepts that Article 3 of the ECHR is applicable in any event. And that does raise the interesting question, which my learned friend did not answer, as to why this claim was not brought as a straightforward Article 3 challenge, to save everybody the pain of the difficult withdrawal agreement and charter arguments. Because if the claimant is right, and this really is a case of inhuman and degrading treatment, then all these arguments about the charter are just have been a huge waste of time.
I suppose that depends upon how you construe Article 1, or whether it is coterminous with Article 3 or adds a little booster. I mean, that's a different argument. But in the margins, there could theoretically be a difference.
On the cases we submit, it's
Understood. Absolutely. I understand that.
But the truth is, this wasn't brought as an Article 3 challenge because Article 3 challenges...
You've made those submissions.
And my learned friend's elegant omission to engage with the elements of the test rather confirms that. So, what the question is under ground 1 is, was the fundamental question raised by Article 4.3 is, was the Secretary of State interpreting or applying Article 13.1 when refusing a claim for universal credit after the end of the transition period? And there are two timing points that I wanted to make by way of introduction to my submissions on ground 1. The first...
I'm hesitating to... Please remember, this is reply. You had half a day to set out your arguments on this. I know you need to reply to 3 people, but we have got a very detailed note of everything you told us the day before yesterday.
I assure you, I don't have very much to say, but it does have an introduction. The first...
Everyone deserves a run-up.
The first important point of timing is that at the end of the transitional period, EU law ceased to apply, save as explicitly carried on by reference in specific provisions of the withdrawal agreement. The UK decided not to be bound by its treaty commitments and not to be bound by EU law as a result of its decision to leave the EU. A good example of that in the withdrawal agreement that I'm not sure you've read or have been taken to specifically by anybody so far is Article 20, which you have in your in the clip, tab 13. That's just an example of the point. Article 21, this is about restrictions of the rights of residents and entry. 21, the conduct of Union citizens or UK nationals exercising rights under this title, where that conduct occurred before the end of the transition period, shall be considered in accordance with Chapter 6 of Directive 2004/38. So the expulsion provisions, when you can be expelled on account of your conduct. If your conduct is pre-end of the transition period, that's EU law, that's the directive, the usual way. But 22, conduct of Union citizens or UK nationals, where that conduct occurred after the end of the transition period, may constitute grounds for restricting the right of residence, etc., in accordance with national legislation. So this is a direct restriction on the rights of residents who may be expelled, but a very clear division between EU law applying pre-end of transition period and not applying post-transition period. And
these are the equivalents of the old Ordre Publique provisions, 1612/68, or that early provision on the
68,
68, something or other.
68/360.
Something like that. So they were in the. I mean, these are the public order. These are the public interest exclusions, which are run throughout, including from the treaty from the earliest days.
Yeah. Exactly. Yeah. And that is why, and that's an illustration of why the court in CG 57, 58, and in particular 59 was absolutely right to make the point that CG's situation falls within the scope of EU law until the end of the transition period. After the end of the transition period, and contrary to some of the submissions made by my learned friend for the IMA, Union citizens living in this country are not within the scope of EU law. They may be within the scope of the withdrawal agreement. They're not within the scope of EU law.
Sorry, I didn't suggest that they were.
Well, they're within the scope of the WA or nothing as international law rights, which then do or do not come into English law under Article 4 and Section 7. I mean, no one's. Are you saying that EU law no longer applies and nothing else does, or EU law doesn't apply and something else does or might?
Well, I'm saying that union citizens like AT are no longer within the scope of EU law after the end of the transition period. They may be, and she was within the scope of the withdrawal agreement,
right?
Which borrows, as my learned friend put it, Lego building blocks from EU law, but it's the withdrawal agreement which is being applied. One of the consequences of no longer being within the scope of EU law, we say, is that the rights flowing from EU citizenship no longer apply. My Lord questioned both in my submissions and in also that there was discussion during my learned friends' submissions as to the point that, well, the withdrawal agreement confers rights on EU citizens. And so it does. The term EU citizens is used, understandably, as the basis for categorising the nationals of the member states upon whom the UK has agreed to confer rights under the withdrawal agreement. But the rights of EU citizens living in the UK are rights under the withdrawal agreement. They are not rights flowing from the citizenship provisions of the treaty. The UK no longer recognises those rights. The second important point of timing is on the relevance and application of Article 21. Obviously, for you, Article 21 is significant in the scheme of Part 2 of the withdrawal agreement, but it's significant for determining the scope of the withdrawal agreement. That's Article 10. The individuals within, in particular, Article 10(1)(a, that's what we've been looking at. These are individuals who exercise their Article 21 TFEU rights to come to the UK before the end of the transition period, such as AT. But that, we say, that is the work of Article 21 done to bring the EU citizen like AT within scope. It doesn't influence the question or the issues that arise then under Article 13. Now, the key question then is, was the Secretary of State interpreting or applying, and he was said to have been applying Article 13 of the withdrawal agreement within the meaning of Article 4.3. And we say that the Upper Tribunal's reasoning in paragraph 116, the key reasoning that sorry, it's not 116, it's 106. That the Secretary of State was acting within the scope of the Article 21 TFEU right to reside when deciding her application for social assistance necessary to make that right effective. That reasoning, which isn't there on the face of CG, is both, we say, incorrect, but also instructive. So there has to be some way of reading CG in its different pre-transition period context into Article 13 of the withdrawal agreement. And the point being made ultimately then is that Article 13 is being applied when deciding a claim for benefit, because the claim for benefit is necessary to make the right effective. And I'm not going to repeat why we said that was wrong, but my learned friend said it was correct and understandable on the basis of the Advocate General's opinion in CG. And He gave you a number of references and read extensively from the Advocate General's opinion, and in particular from the Advocate General's reference to the case of Chavez. But if you follow through the reasoning of the Advocate General, you will find, I admit, that it does not support my friend's submissions and doesn't support the reasoning of the Upper Tribunal. What the Advocate General, the context in which the Advocate General applied Chavez, starting just above paragraph 103 of the Advocate General's opinion in CG, tab 59 upon 3, was in the context of justification in the light of fundamental rights of the obligation to provide for an examination of individual situations. So he's gone down this route: indirect discrimination, justification, not reflected in the court's judgment. And when coming to justification and asking, can the member state be justified in saying that we're not going to look at individual situations, or can it be justified to require the member state to look at individual situations, he relies on Chavez. And paragraph 109 is the key paragraph in my submission, where he transposes the individual assessment of children's needs, which one sees in Chavez, and says effectively, well, if member states are required to look in detail at individual children's needs in that context, no reason why they shouldn't be required to do so in relation to normal family life in the benefits context. I don't need to say whether he was right or wrong about transposing Chavez, but the point is, none of this is a decision to the effect that a decision on benefits entitlement is something that goes to making a resident's right effective.
I don't follow that. When I was reading Chavez, I identified 5 paragraphs in which they say, in relation to children, that you have to give the right in order to make it enjoyable, so peaceful, and then 1 paragraph in which they refer to FAUT, effectiveness. So there's 2 different justifications. Then we have to ask ourselves what the anchoring right is here, what CG treats as the anchoring right. If the anchoring right, as per CG, is either exercise of the right prior to the transitional period of Article 21 or rights under Article 21, so it's either right of residence under the treaty or under the WA. There's, I think, 6 or 7 paragraphs which refer to that as the anchoring right. Then you ask yourself, what is the function of an application for subsistence? Chavez would suggest it's either to ensure proper enjoyment of the right or to ensure it's effective. Why would that be? Why would that disqualify you from the right in the first place? That is designed to protect the right. The failure to apply for it doesn't mean to say you lose the right. It just means it's not enjoyable or not effective. When you apply, even outside the transition period, you're still protecting the right which you had before the transitional period. And I'm not quite certain why the disqualification is the date of application for a sum of money, when it seems to be the anchoring right is that which occurred before the transitional period, a right of residence under Article 13 or Article 21 or both. Isn't that where Chavez comes in? I mean, it just tells you what the function of the application for subsistence is, or benefit. It's simply to protect the right you already have.
Well, no, my lord, in my submission, Chavez doesn't tell us that. Chavez isn't a case about benefits at all. It's a case about the Zambrano right.
It's about a right, enforcement of a right.
Well, it's about a right of residence, whether there was a right of residence in this particular variation on the Zambrano situation, where one parent has to leave the country, and can the child stay with the other parent in the UK? So the main in Holland, in that case, the main carer leaves. Is it sufficient that the child can stay with the secondary carer? So it's not a case about benefits. It is a case where the
not monetary benefit, it's about that which makes the right effective or enjoyable, which may be a benefit. It may be the right to have your carer. It's something collateral.
Yeah, and my Lord, well, it's a right, but of course the right, the Zambrano right, which they're discussing in Chavez, is the right to live somewhere in the EU, and which comes back to which is also part of my submission in this area of the case, that it's simply not an available argument to say I have a right of residence in a member state and I need to make that effective by claiming benefits, even in circumstances where the secondary legislation says I can't. So really, Chavez and the Advocate General's reasoning certainly doesn't help in defending the Upper Tribunal's analysis, and I maintain, and I haven't got over it, that Mirga is directly contrary to the Upper Tribunal's analysis. In substance, I mean, one can argue about whether the situation of Ms. Mirga was analogous to that of AT. I would say that it was. Neither had a right of residence which attracted social assistance entitlement, but whatever. The first argument being made by Mr. Drabble in that case was very similar to the point being made by the Upper Tribunal. I need to stay in the UK and I need benefits to make that effective.
Is that your introduction?
Actually, I failed to say when I passed from the introduction into the main part of it. So we say there is no support for the Upper Tribunal's attempt to square the circle in paragraph 106, and I note that my learned friend Mr. Demetrio didn't adopt Mr. Delamere's submissions in that regard. She had a different approach, whereby it was said simply, well, the UK was acting within the scope of Article 21 when it granted the right of residence before the end of the transition period, and it must bear the consequences of it. It must be assumed to continue to be interpreting and or applying Article 21 when it rules on a claim for benefits which happens to be made after the end of the transition period, just as before the end of the transition period. But we say that doesn't take into account the first of the timing points and the end of EU law, or the end of being within the scope of EU law at the end of the transition period. But nor does it answer the central question of how was the Secretary of State applying Article 13 of the withdrawal agreement in refusing the claim for benefits. And making submissions about what Article 21 might or might not have implied, brought with it, required for the end of the transition period, well, that might be an attempt to read CG across into the post-transition period situation, but it doesn't answer the central question: how was Article 13 being applied? And just to be clear, Article 13 was not being applied when the right of residence was granted to CG in the first place. That was granted pursuant to Article 18 of the withdrawal agreement, and all subject, of course, to Article 23 on equal treatment where it's recognised, or from which it's recognised that AT doesn't benefit. So the grant of leave was not an application of Article 13. The grant or refusal of benefits was not an application of Article 13. That was governed by Article 23. And nor, fundamentally, is the UK, in deciding upon benefits claims, continuing to recognise or apply citizenship rights. Second timing point, those rights were spent when Article 10 brought the claimant within scope. And finally then, a couple of words about Article 4.1, about the legal effects of the withdrawal agreement. That's the phrase that it used, not the substantive content of the withdrawal agreement. And you merely have to look at the other limbs of Article 4, in particular 4.3, 4.4 and 4.5, which do deal with content of the substantive law. Article 1 and indeed Article 2 is plainly about mechanism for legal effect. That's consistent with Alistair, and is the answer to the point that the Upper Tribunal took against us, which was that we couldn't explain the reason for having Article 4.1 first paragraph as well as second paragraph. My learned friend's explanation of Article 4.1, what it did, and the idea that it was about ensuring uniform application of EU law, my submission is inconsistent with Article 4.4. There is going to be necessarily inconsistency between the UK and the member states as to what they regard EU law to be. For the purposes of the withdrawal agreement, EU law ends at the end of the transition period, Article 4.4. The member states will continue in their non-withdrawal agreement activities to be bound by EU law as determined by the Court of Justice thenceforth, but we won't. So Article 4.4 simply puts paid to any idea of continuing uniformity of application, and with all due respect to the Tribunal, puts paid to its reasoning in paragraph 110.
That's it. After the transitional period and subject to the 8-year transition for the WA, we can take into account.
Yes, that's 4.5.
So it might mean that there's inconsistency. It doesn't necessarily mean.
It doesn't necessarily mean, but there is no
There is a possibility. Yeah, I understand.
There is no provision for consistency.
Yes. They plainly watered that down. Yep.
Those are my submissions.
Thank you very much indeed, Mr. Cockburn. Well, can I thank all of you? There's a cast of thousands, and I'm very conscious of the enormous amount of work that's been put in by all of you in producing the skeleton arguments, the submissions, and all the references. And we are all extremely grateful, because without that amount of work that's been done, I should also say the solicitors as well as the rows of junior counsel behind the leaders, we simply wouldn't have been able to get through the amount of work and have grasped the complex arguments in this case in the way that I hope you'll think we have.
Can I thank the court for expediting this case in the way that it has, because obviously there are a number of people who are substantially affected by the results of this case, and getting clarity one way or the other is vital. So thank you very much.
Well, we're glad to oblige, but in reality, we're now in the fortunate position that we've been able to reduce the backlogs in the Court of Appeal, so we've got some more flexibility in putting in important cases urgently. You won't be surprised that we will be reserving our judgments. We're not going to give them to you on Monday morning. They'll be sent out in the normal way, in draft, typographical, grammatical, and minor factual errors, please. It's not an invitation to treat. We've had your very extensive arguments and written material, and we'll work on that basis. Please, in any case, but in an important case like this, please be very aware of the terms of the new embargo, and we will expect the lists that are required as to exactly who is going to have access to that draft judgment before it's perfected and handed down. Be handed down electronically. We'd hope we'd be able to deal with all other matters in writing. If there's any difficulties, we'll deal with any applications in writing. Very well, unless there's anything else that anyone needs us to deal with. No? Well, thank you all very much, and thank you again for sitting down.